13-year-old Paris Lee Bennett knew exactly what he was going to do to his sister. Hev was born in 1993 in Abilene, Texas. His mother, Charity Lee, was just 18. She carried her own deep trauma, convinced that her own mother had plotted to end her father's life. That belief haunted her, and it shaped the home Paris grew up in. Charity struggled with addiction and emotional instability. Their home life was chaotic. Paris began showing disturbing behavior early on. Before he turned 13, he was diagnosed with traits of antisocial personality disorder. Then came the night of February 4th, 2007. Paris told the babysitter she could leave. His mother was still at work. Alone with his 4-year-old sister, Ella, he led her to her room. He held Ella until she could no longer breathe, then struck her 17 times with a sharp tool. Afterward, he fled the house. He later said the reason was simple. He wanted their mother to suffer. At 11:42 p.m., Paris called emergency services. He calmly claimed an intruder had broken in and harmed his sister, but when asked to give first aid, he only pretended to follow the dispatcher's instructions. He paced the room, spoke with eerie control, and gave no sense of urgency. At one point, he referred to Ella as a pumpkin-headed demon who had targeted him. But by the time help arrived, Ella was already gone. Paris's plan was clear. He wanted to punish his mother. He believed harming Ella would cause her the greatest pain. He was only 13 at the time. Texas law did not allow him to be tried as an adult. His case went through juvenile court. He faced the most serious accusation for someone his age. He accepted a deal and admitted to the act. He received 40 years behind bars, the maximum for a juvenile. He can ask for parole after 20 years in February 2027. After years in a youth facility, Paris moved to an adult prison at age 19. Mental health experts evaluated Paris. They found signs linked to antisocial behavior. He described what happened in clinical detached terms. He showed no remorse. Some specialists see these as psychopathic traits. His careful planning and emotional distance stand out. As February 2027 approaches, one question remains. Will Paris be granted parole? His lack of regret and the planning behind his actions work against him. Will the board ever see a genuine change? Charity Bennett stayed in touch after the conviction. She felt both guilt and love. Their story was told in the 2017 documentary The Family I Had. For a time, she held on to hope. In 2021, she learned Paris had formed a relationship with a prison partner linked to more plans of harm. She then cut all contact. She changed her name and moved. She hoped to shield her surviving child from this ongoing pain. The next children set traps, then waited for their dad. Richard Ritchie John Jonke was born in 1966. His sister, Deborah Ann Jonke, was born about a year earlier in 1965. They grew up in Cheyenne, Wyoming. Their dad, Richard Chester Jonke Sr., was 38 and worked as an IRS investigator. Their mom, Maria, was quiet and watched what happened at home. On the outside, the Jonke home looked stable. Inside, it felt very different. Their father ran the house with strict rules. Deborah was not allowed to date. Both kids stayed apart from other children. Neighbors said discipline was harsh. Behind closed doors, things got worse. Their dad had been an army sergeant. He used physical punishment often. He hit his children and his wife regularly. Over time, his control grew extreme. Deborah faced inappropriate contact. Richard Jr. was hit for small mistakes, walking with his mouth open or even coughing. This happened almost every day. Maria saw it all but felt too afraid to step in. Before that night in 1982, neither child had any legal trouble. Then everything changed. On November 16th, their dad struck Richard Jr. again. After that, Richard and Deborah saw a chance. Their parents left the house for dinner. The kids put a plan into motion. Richard gathered every gun he could find. He set traps around the garage. He stood in the dark with a 12-gauge shotgun loaded with slugs. Deborah stayed inside with a .30 caliber carbine for backup. They sent their dogs to the basement and dimmed the lights. At about 6:15 p.m., their father came home and walked toward the garage. Richard fired 6 times through the door. 4 of those rounds hit his father and ended his life immediately. When police arrived, Richard admitted why he did it. "I shot my father for revenge," he said. But in court, more came out. Years of fear and helplessness had built up. Richard said he wanted to stop any more harm to his family. Deborah said she helped Richard carry out the plan. Later, she felt deep regret when she saw what happened. Why would 2 teens plan such a tragic event? Their court case gave an answer. They had asked for help many times. No one stepped in. They felt trapped with no other choice. They turned to force as their only answer. Their trial took place in spring 1983. News reports revealed how much the children had suffered. Public sympathy shifted toward them. Expert witnesses spoke about battered child syndrome. They said the constant mistreatment changed how the siblings saw danger. The defense asked for details about that history. The prosecution argued the plan was carried out on purpose. In the end, the jury lowered Richard's charge to voluntary manslaughter. Deborah was found guilty of helping with voluntary manslaughter. Richard received a sentence of 5 to 15 years. Deborah was given 3 to 8 years. Both sentences allowed for parole once they served the minimum term. By October 1985, Richard had spent just under 3 years in the Wyoming boys' school. He turned 19 and walked free. He went back home. He signed up for community college and took on part-time work. Up next is the story of a jealous teen who lured her friend into a nightmare. On January 11th, 1992, Madison, Indiana, looked calm. No one guessed what would happen to 12-year-old Shanda Renee Scherer. Shanda was born on June 6, 1979, in Kentucky. Her parents were Stephen Scherer and Jacqueline Vaught. She loved cheerleading, volleyball, softball, and basketball. Her friends said she was bright and full of energy. She laughed easily and dreamed big. Under the quiet surface of Madison, a painful love triangle was taking shape. 16-year-old Melinda Lovelace could not accept that her former partner, Amanda Heverin, had moved on with Shanda. Melinda's anger turned into an obsession. She recruited 3 friends, Lori Tackett, 16, Tony Lawrence, 15, and Hope Rippey, 16. They joined her out of loyalty or fear. Melinda had a troubled home life filled with anger and neglect. Lori, Tony, and Hope felt insecure in their own ways. None of them guessed how far Melinda's need for revenge would go. Late that January night, they lured Shanda to an isolated summer house. For almost 8 hours, Shanda suffered terrible harm. They burned her skin. They beat her. They wounded her with a sharp object. They used force to stop her from breathing. They forced unwanted touching. They tied her up. They humiliated her. Each act grew worse than the one before. An examination later showed rope marks on her wrists. There were cuts on her head, neck, and legs. Her fingers were crushed. Her teeth were removed to confirm who she was. What could push teenagers to such cruelty? For Melinda, jealousy made her see Shanda as an intruder in her life. She believed that hurting Shanda would win back what she had lost. At first light, they set her body on fire and left her to perish. The horror shook the entire town. Police soon named the 4 suspects. Faced with clear proof and guilt, each girl admitted what happened. Melinda and Lori were charged with taking a life, holding someone captive, and arson. Tony admitted to holding someone captive. Hope went to trial on similar charges. In 1992, the courtroom was heavy with emotion. Shanda's family sought answers. Melinda and Lori showed no reaction as the details came out. Witnesses described the full extent of Shanda's suffering. Melinda and Lori made plea deals. Each got 60 years in prison. Tony received 20 years. Hope, after admitting she held Shanda against her will, also got 20 years. Why such long terms for teenagers? Prosecutors argued that no matter your age, extreme cruelty must bring serious consequences. These agreements let them seek the harshest punishments. Melinda and Lori went to adult facilities. Lori was released early in 2015. Melinda gained her release in 2018. Tony and Hope were freed sooner under different rules. The next victim was an 8 months pregnant woman who was found lifeless in bed. The main suspect? An 11-year-old. Jordan Anthony Brown was born in 1997 in New Beaver, Pennsylvania. He lived with his father, Chris Brown, who raised him as a single parent. Their bond was close. Jordan loved the outdoors, especially hunting trips with his dad. For his 11th birthday, Chris gave him a youth model 20-gauge shotgun. It was legal in the state. At the time, it felt like a rite of passage. No one imagined that gift would later sit at the center of a national headline. On the morning of February 20th, 2009, tragedy struck. Inside their farmhouse in nearby Wampum, Chris's fiancée, 26-year-old Kenzie Marie Hauk, was found lying in bed. She had been shot once in the head at close range. She was 8 months pregnant. Her unborn son didn't survive either. Police arrived quickly. There was no sign of forced entry. No one else was known to be in the house except for Jordan and his 7-year-old stepsister. Investigators formed a theory almost immediately. They believed Jordan had taken his shotgun from a corner of the house, walked into the bedroom, and fired while Kenzie was still asleep. Then, they claimed, he returned the gun, cleaned himself up, and casually walked his stepsister to the school bus as if nothing had happened. The case rested on a few key pieces of circumstantial evidence: small red droplets found inside the home, a spent shotgun shell on the way to the bus stop, and testimony from Jordan's stepsister. At first, she said she hadn't seen or heard anything, but after multiple interviews, she said she remembered a loud boom and later claimed she saw Jordan holding a gun. There was no DNA, no fingerprints, no gunshot residue, and no red stains on Jordan's clothes. Experts couldn't even confirm that his shotgun had been fired, or that it was the weapon used. Still, prosecutors moved forward, convinced jealousy and resentment over the new baby had pushed him to act. Key testimony came from that stepsister. At first, she said she saw nothing and heard nothing. Later, after several interviews, she said she saw Jordan with a gun. She said she heard a big boom. Then she said they went on to catch the bus together. In April 2012, a juvenile court judge found Jordan responsible for first-degree charges of Kenzie and her unborn child. The judge also treated the case as if it were an adult case. Jordan was ordered to stay in youth detention until he turned 21. Doubts came quickly. In May 2013, the Pennsylvania Superior Court called the juvenile court's ruling an abuse of discretion. That court wiped out the earlier decision. But 2 years later, in 2015, another hearing again found Jordan responsible. In September 2016, a split vote on the same Superior Court panel upheld that finding. Jordan stayed quiet through all of this. His father and lawyers spoke for him. They said they were heartbroken. They said the system had failed a child. On July 18, 2018, the Pennsylvania Supreme Court finally stepped in. By a unanimous 5-0 vote, it reversed Jordan's liability finding. The justices said the evidence was too weak. They noted that the gun in his room might not have caused the injury. They pointed out that the case relied only on indirect clues and shaky testimony. Justice Deborah Todd wrote that the case against Jordan did not overcome the presumption of innocence. She ordered that he be released. That decision also meant he could never face the same charges again. Because Jordan's case stayed in juvenile court, he never had a final adult sentencing hearing. The court's release order was the last formal ruling in his case. After his release, Jordan moved to Ohio. He studied computer science there. In 2020, he filed a federal lawsuit. He claimed that state troopers had shaped evidence and unfairly influenced his stepsister. He said they ignored other possible leads, including Kenzie's former boyfriend, who had a restraining order and had threatened her. In December 2024, a jury found that the officers had not violated Jordan's rights. Yet Jordan still seeks recognition and compensation. He speaks openly about his struggle with post-traumatic stress. He says he plans to become a civil rights attorney. He wants to help others who face similar challenges. The next child said he'd make history. What he meant, no one saw coming. Craig Price was born in 1973 in Warwick, Rhode Island. As a young teen, he already had run-ins with the law. He had charges for breaking into homes, petty theft, stalking, aggressive behavior towards his family, and substance use. At just 13, he already had a growing rap sheet, something that set him apart from other kids in the neighborhood. To people nearby, he often seemed friendly. He played football, laughed with friends, and rode his bike like any other kid. No one guessed what would happen next. On July 27, 1987, just before his 14th birthday, Price crept into the home of 27-year-old Rebecca Spencer. Her house was only 2 doors down from his. He carried a sharp tool. He waited until she fell asleep. He used it to inflict 58 wounds. Rebecca did not survive. The neighborhood was stunned. No one thought someone so young could cause such harm. She had just moved in and was preparing to start a new job. Her young son was away at the time. 2 years later, on September 1, 1989, Price was 15. He had been using different substances that day. He entered the Heaton home planning to steal. When 39-year-old Joan Heaton confronted him, he flew into a rage. He used a sharp tool and caused 57 wounds. Then he turned on her 2 daughters. 10-year-old Jennifer suffered 62 wounds. 7-year-old Melissa suffered 30 wounds. He even crushed her skull with a kitchen stool. Neither girl survived. He left their bodies stacked and hidden under a rug. He even tried to clean up the scene. After the Heaton incident, Price kept his cool for only a few days. On September 5th, police saw fresh cuts on his hands. He could no longer pretend. Officers searched his home. They found red-stained clothes and more sharp tools. Price broke down and admitted what he had done. He even acted out parts of the events. He showed no remorse during the confession, just calm, matter-of-fact descriptions. At that time, Rhode Island law would not let a juvenile offender serve time past age 21. So Price went to family court. He was sent to a youth training facility. He was to stay until he turned 21. His record there was sealed once he left. Families of the victims and the public were outraged. Lawmakers rushed to try to change the laws, but it was too late. Still, Price boasted that he would make history once free. He refused any mental health checks. Experts warned he would act out again without help. In media interviews, he smiled and spoke confidently about his crimes, fueling public fear. Just before his planned release in 1994, he threatened a staff member. He was found guilty of extortion. That added 7 more years to his stay. He also fought against psychiatric exams in court. In 1997, he lost that fight and got 25 extra years, though 15 were suspended if he cooperated. Inside the adult system, he stayed dangerous. In 2009, he harmed a prison officer in Florida. In 2017, he harmed another inmate. That added 25 more years. He was transferred from Rhode Island to Florida after repeated behavioral issues. All of this makes Craig Price one of the system's most dangerous inmates. Each of his early cases was handled in youth court when he admitted guilt. His later offenses were tried in family court and remain on record. He now serves his term at Union Correctional in Florida. At his contempt hearing, Price said, "I know what I've done, but I need my chance to make things right. I want to rebuild my life." For a moment, he spoke about change, but with a record like his, few are willing to listen. The next case is of the most brutal acts Florida had ever seen, and the suspect was barely 14. Aiden Sean Fucci was born in 2006. His parents are Crystal Smith and Jason Fucci. He grew up in St. Johns County, Florida. By most accounts, he did okay at school. He paid attention when something caught his interest. Otherwise, he blended in with other students. His grandmother said he had some good qualities. She also asked the court not to send him away forever. On May 9th, 2021, Mother's Day, Aiden led his 13-year-old classmate and cheerleader, Tristan Bailey, into a small wooded area in the Durbin Crossing neighborhood near St. Augustine. Security cameras show them walking together around 1:45 a.m. Hours later, Aiden walked out of the woods wearing only his shoes. Tristan did not come back. Searchers found Tristan nearby. She had 114 deep wounds. Almost half of those marks were on her hands, arms, and head. Those cuts showed she tried to shield herself. Investigators also found talk he had earlier about wanting to use a sharp tool on someone in the woods. He had never said who he meant. The sharp tool he used was his own folding sharp tool, missing its tip. That object was found near Tristan. At Aiden's home, police saw his clothes soaked with red. They also noticed places where someone had tried to wash them. When the case reached court, no one could find a clear reason for what he did. The judge said it was not about money, revenge, or any strong feeling. The judge said it happened just to satisfy this child's own urge to see what it felt like to take a life. Aiden was taken into custody soon after Tristan's body was found. At first, he faced a lesser charge. Later, prosecutors raised it to first degree because of how brutal the act was. In June 2021, he pleaded not guilty. By February 6th, 2023, just before a jury could be picked, he changed his plea to guilty. In court, he said, "I plead guilty and I'm sorry to the Bailey family and my family." The sentencing hearing spanned 2 emotional days in March 2023. Family members spoke about how they had been hurt. Tristan's older sister, Alexis, dropped 114 small stones into a jar. Each stone stood for one of Tristan's wounds. Her mother, Stacy, asked the judge if Aiden stopped to see how Tristan was doing or if he left her alone. Tristan's family said they wanted him to serve the full term. Stacy told the court she believed he could not change. Aiden's grandmother and parents wrote letters asking for leniency. Aiden also wrote an apology. He said he knew sorry would not bring Tristan back, but he hoped it might help in some way. On March the 24th, 2023, Judge R. Lee Smith gave Aiden the maximum sentence for a young offender. He will remain in prison for life, with a chance at review after 25 years, as Florida law allows. The judge noted he had never seen a case so disturbing, and he spoke about the suffering Tristan endured. By early 2025, Aiden, now 18, was moved to Florida State Prison's Reception and Medical Center, West Unit in Lake Butler. His family's appeal attempts were already turned down. His sentence remains in place. Around March of 2048, he may ask a court to look at his time again. The next teenagers wore hockey masks. They poured gasoline, but they had the wrong address. Kevin Bowie was born in 2003. He grew up in Lakewood, Colorado. His parents came from Vietnam and worked hard. When Kevin was young, he lived in what he later called the projects. By high school, his father ran an accounting firm. The family moved into a bigger house with mountain views. Kevin did okay in school. He played football as a linebacker and swam well. He liked to wear Air Jordans and Gucci belts. Kevin had another side. He and his sister sold illegal substances through Snapchat. He also planned to get credit card numbers to use without permission. He collected weapons too. In July 2020, Kevin tried to buy a firearm with a friend in Denver. Instead, someone took their cash, shoes, and phone. He felt embarrassed and angry. He wanted to get back at those who did this to him. Kevin's actions got worse quickly. After losing his phone, he used the Find My app to find it. The app led him to 5312 Truckee Street in Denver. Upset and wanting to strike back, he asked two classmates, 16-year-old Gavin Seymour and 14-year-old Dylan Siebert, to join him. They looked up the address over and over. Kevin checked it 13 times, even on a real estate site, to plan what they would do. Late on the night of August 4th, 2020, around 1 a.m., the three teens bought hockey masks and cans of gasoline. They used an unlocked back door to enter the house. Kevin poured gasoline in the living room, then he lit it. Surveillance cameras saw them leaving at about 2:40 a.m. This was not random. They planned every step and meant to cause the worst harm they could to anyone inside. They had the wrong house. Two Senegalese families lived there, the Diols and the Bayes. 5 people did not survive after breathing in smoke. They were Jibril Diol, 29, his wife Aja, 23, their toddler daughter Khadija, 22 months, Jibril's sister Hassan, 25, and her baby Hawa, 6 months. 3 others got out by jumping from second-floor windows. Kevin really thought the people who took his phone lived there. He based his choice on that app. But tracking the phone didn't make his plan right. When they set fire to the house, the result was a disaster. Flames and smoke brought fear and confusion to the neighborhood. Detectives Neil Baker and Ernest Sandoval had a tough case. No one saw the teens clearly. They got a warrant to access cell tower data. They also got a judge's permission to view Google searches for that address. Some argued the warrant was wrong. In October 2023, the Colorado Supreme Court decided it was allowed under certain rules. Arrest orders came next. All 3 teens were taken into custody on January 27, 2021. They faced many counts. The charges included planning to take lives with planning, setting a fire on purpose, breaking into a home, and trying again to take lives. In court, all 3 agreed to plea deals. Dylan Siebert, 14 at the time, admitted to second-degree taking of a life. He went to juvenile detention for 3 years. Then he moved to a young offenders program for 7 more years. That makes 10 years in total. Gavin Seymour admitted guilt as well. He received 40 years in prison, the longest under his deal. Kevin B. was seen as the leader. On May 17, 2024, he admitted guilt to 2 counts of second-degree taking of a life. In return, about 60 other counts were dropped. Those included planning first-degree taking of lives, setting a fire, breaking in, and trying to take lives again. On July 2, 2024, Judge Karen Brody sent Kevin to state prison for 60 years. She split that into 2 30-year terms served back-to-back. That was the maximum allowed under his plea. He will serve his time in Colorado's correction system. He gets credit for time he already spent locked up. The reason for so many years was clear. Prosecutors said Kevin planned the whole plot. They said he persuaded his friends to join him. They argued he moved from wanting payback to taking many lives. In court, Kevin appeared in shackles and a green jumpsuit. He wore glasses and spoke slowly. He seemed deeply sorry. He said, "I take full responsibility. It is not Dylan's fault. It is not Gavin's fault. I just wish it doesn't haunt you any longer. I hope you can find some calm and happiness again." At his sentencing, he added, "I was an ignorant fool blinded by anger. I am a failure who threw away my life. I have no excuses. I have no one to blame but myself." He said he wasn't asking for forgiveness. He only wanted the families to find some peace. Now meet 2 middle school boys who did what could be described as the unthinkable. Andrew Golden and Mitchell Johnson were students at Westside Middle School near Jonesboro, Arkansas. Andrew was 11 years old and lived in a home with many firearms. He often joined shooting clubs and contests. At school, he got into fights and once shot a classmate's cat with a BB gun. 3 months before the event, he told a counselor he planned to open fire on classmates, then said it was just a bad dream that stopped him. 13-year-old Mitchell loved street gangs. He talked about joining the Bloods and about using pot. He once threatened a former girlfriend and brought weapons to school. Andrew and Mitchell bonded over their interest in guns and hostility toward others. On March the 24th, 1998, The first day back after spring break, things escalated. During fifth period, Andrew pulled the fire alarm. As students and teachers poured outside, the boys fired from a nearby hill. They used rifles, pistols, and revolvers taken from Andrew's grandparents' unlocked collection, along with 200 rounds of ammunition. Their bullets struck people fleeing for safety. 4 students, all aged 11 or 12, and one 32-year-old teacher lost their lives. 10 more were wounded in the ambush-style shooting. Police soon caught the pair as they tried to escape in a stolen van. It was packed with camping gear, a crossbow, hunting tools, and more firearms. Did they plan this well in advance or act on impulse? Evidence pointed to both. Mitchell spoke openly of wanting revenge and harming those around him, especially girls. Andrew seemed driven by a mix of fear and anger. In court, Mitchell said Andrew had told him, "I'm tired of people picking on me, so I want to scare them." Many saw Andrew as the main instigator. Their motive grew from anger over bullying and a wish to feel powerful. Arkansas law requires anyone under 14 to be handled in juvenile court. In August 1998, both boys faced charges including capital offenses, attempted harm, and illegal possession of firearms. Despite public calls for tougher penalties, the law limited their detention to age 21. Judge Ralph Wilson observed, "The punishment will not fit the event." At trial, Mitchell read an apology letter. He said his thoughts were with the families who had lost loved ones. He added that he hoped people would one day see the real Mitchell. He later admitted he was just marking time in detention. Andrew's defense argued he struggled with mental health issues. In the end, both were found delinquent and ordered to stay locked up until they turned 21. Mitchell served about 7 years and 4 months, leaving on his 21st birthday, August 11, 2005. Andrew stayed around 9 years and 2 months, leaving on May 25, 2007. After that, their juvenile records were sealed. In 2017, families of the victims won a civil suit. A court awarded them $150 million in damages. Collecting that sum was unlikely. The aim was to stop Andrew and Mitchell from ever benefiting from what they had done. After release, both men stayed out of the spotlight. Andrew legally changed his name to Drew Douglas Grant and lived in Missouri until he passed away in a head-on car crash in July 2019. He left behind a wife and child. Mitchell returned to custody briefly in 2007, 2008 for weapons and soft substance charges, and again in 2008 for theft. He finished those sentences and around July 2015 moved into probation and a rehabilitation program in Texas. Later, Mitchell applied for a concealed carry permit, stirring public debate. New rules soon made it harder for those with juvenile records to get such permits. Andrew's own application was denied because he gave a false address and because of his juvenile record. But could revenge go even further? The next story involves a teen who ended his entire family. Nicholas Wagner Browning was born in 1992 in Maryland. He was the oldest of 3 boys. His parents were John, a 45-year-old lawyer, and Tamara, a 44-year-old stay-at-home mom. They lived in a comfortable house in Cockeysville, Baltimore County. His younger brothers were Gregory and Benjamin. He went to Dulaney High School. He did well in his classes. He played on the lacrosse team. He also golfed, skied, and joined the Boy Scouts. His father was his scoutmaster. On the outside, things looked normal. The family took trips to Deep Creek Lake, but Nicholas later said his father was very strict. He even claimed his father sometimes hit him. On the night of February 1st, 2008, just before his 16th birthday, Nicholas put a plan into action. He quietly entered each family member's bedroom around midnight. He had his father's handgun. He shot his father first, then he shot his mother. Finally, he shot his 2 younger brothers while they slept. All of this happened at their home on Sherwood Road. Afterwards, Nicholas left the handgun nearby. He walked to a friend's house. He said he came back to find his family's bodies. He asked that someone call 911. Police arrived and arrested him at about 1:05 a.m. on February 3rd. Nicholas later admitted he had argued with his father and then used the gun on each family member. He also said he looked forward to a large inheritance and life insurance. Officials debated his true motive. Nicholas insisted his home life was unbearable. Prosecutors argued that did not explain why he harmed his younger brothers. One prosecutor said he didn't want anyone telling him what to do and saw this as a way to gain both freedom and money. He was tried as an adult on 4 counts of first-degree wrongdoing. In January 2009, he took a plea deal. This avoided a full trial and removed the possibility of a capital sentence. At sentencing, the calm, methodical way he carried out the act was highlighted. His defense team pointed again to the pressure he felt at home. The judge gave him 4 life terms, with 2 of those served back-to-back. Under Maryland law, he must serve at least 23 years before he can ask for release. That makes him eligible around 2031. He is held at Western Correctional Institution in Cumberland, Maryland. In 2014, he asked for a shorter sentence, citing his youth and signs of change. The court denied that request, noting the gravity of what he did. In recent years, Nicholas has tried to show personal growth. His essay, Little Gardens, won a prison writing prize in 2020. In it, he wrote, "I was 15 when I destroyed the ones closest to me. My life terms strike me as entirely appropriate." Up next is a 10-year-old raised in hate, driven by fear. But what made him snap? Joseph Hall was born in 2000. His parents were Jeff Hall and Letitia Neal. He grew up in Riverside, California. His home was unstable. Money was always tight. Child welfare stepped in when his twin half-siblings were found living in very poor conditions. In 2004, Jeff won full custody. He later married Krista McCary. They had 3 daughters. Under Jeff's control, the home became aggressive. Jeff Hall was a plumber who lost his job during a downturn. He joined an extremist group and quickly rose to lead its Southwestern States chapter. He organized rallies and wore uniforms with hate symbols. He even gave Joseph a belt buckle with one of those emblems. Jeff took his son on armed patrols near the border and exposed him to extreme views from an early age. Joseph showed troubling behavior early on. He was kicked out of several schools. He had anger outbursts and once grabbed a teacher by the neck. He also struggled with ADHD and had below-average grades. In the early morning of May 1st, 2011, a white supremacist meeting ended at the Hall House around 4 a.m. Joseph quietly slipped downstairs. He went to an upstairs closet where his father kept a loaded .357 revolver. His stepmother was asleep in the next room. Joseph stood behind the couch where his father lay sleeping. At point-blank range, he fired one shot behind his father's left ear. His father did not survive. When officers arrived, Joseph calmly said, "I shot Dad." Later, he asked, "How many chances do people usually get?" His question showed both confusion and a wish for a second chance. Joseph later explained what drove him. He said he was terrified and desperate. He described nightly beatings. He said Jeff threatened to burn down their home. The boy said he planned the shooting days in advance. He even talked about it with his sister. He told investigators he got the idea from a TV show where a child shot a parent who had mistreated them and faced no punishment. Why that night? Years of cruelty at home and extreme teachings pushed him over the edge. He saw no escape except this act. He thought it might protect him and his family. After he confessed, Joseph was taken into custody. During questioning, officers read him his rights. He misunderstood "stay silent" to mean "stay calm." Only after an officer's correction did he repeat them correctly. His question about chances revealed the innocence of a child and fear of punishment. Psychological tests confirmed his ADHD, low academic ability, and repeated trauma from danger at home. The trial began on October 30th, 2012. The judge ruled that Joseph was responsible for his actions. The court said the shooting was intentional, though not planned long before that morning. He received a 10-year term in a juvenile facility. State law meant he would be released by his 23rd birthday on June 19th, 2023. He could apply for release after 7 years at age 17. The judge noted that juvenile placement could help him heal or make him harder. His future would depend on what happened next. His lawyers appealed. They argued that a 10-year-old could not fully understand his rights or knowingly give them up. Both the state's highest court in 2015 and the U.S. Supreme Court in 2016 declined to review the case. This kept the ruling in place. Child advocates spoke out against those decisions. They pointed to studies showing that children at his age cannot grasp complex legal rights. Up next are 12 years old, a rock, a sharp weapon, and broken trust. On February 15, 2003, in Ephrata, Washington, two 12-year-old boys, Evan Drake Savoy and Jake Lee Eakin, invited their 13-year-old friend, Craig Martin Sorger, to Oasis Park by saying they would play together. Craig trusted them and went along. Once they reached a quiet spot, things turned tragic. Evan dropped a rock onto Craig's neck. Craig fell to the ground. Then Evan used a sharp object to wound Craig at least 39 times. His head, neck, chest, and torso were all hit. Jake joined in. He swung a sturdy tree branch at Craig's legs and head. Craig was vulnerable. He had autism and ADHD and had been teased at school. He had just moved to the area. His trusting nature made him easy to lure. Evan and Jake had been close since they were toddlers. Evan was outgoing and the class clown. He had a newspaper delivery job and teased those he felt were weaker. Jake had a speech difficulty and had often been teased by others. They formed a bond over shared days at the playground. After the incident, they left Craig's body in a pile of leaves. They left the rock and branch nearby. Craig's body was later found by a passerby. An examination showed dozens of sharp and blunt wounds. When questioned that night, both boys said Craig had fallen from a tree while they watched. There was nothing to support that story. 2 days later, on February 18, 2003, both were taken into custody and held at the Youth Detention Center in Grant County. Officers found a note in Evan's belongings that planned more acts. Jake's journal showed he admired real-life shooters. Investigators saw a clear pattern. Both boys were tried in adult court, a first in Washington state since 1931. In 2005, the state's highest court confirmed they should face adult proceedings. Jake changed his plea in 2005. He admitted to second-degree wrongdoing and agreed to testify against Evan. Prosecutors asked for an 8-year term, but the judge gave him 14 years, finding no reason to lessen the punishment. Evan kept claiming he was innocent until April 2006. Then he was found responsible for first-degree wrongdoing and given the maximum term of 26 years. In 2011, his conviction was overturned due to errors in how parts of the hearing were closed to the public and family members. He faced another trial, but chose instead, in November 2013, to plead guilty to second-degree wrongdoing. He was given a 20-year term on March 25, 2014. Jake served his full term. He left prison in 2017 and later took part in anti-abortion activities. He even left his work release program in 2016 without permission but was quickly returned. He has had a few minor run-ins with authorities since then. He now lives in South Carolina with his wife and 2 daughters. Evan completed his term and was released in February 2023. He now lives in Tacoma with his wife and daughter. Both have served their time and moved on to build new lives. In the next case, one boy lay injured. The other called 911 and asked to be punished. Jamarion Lawhorn grew up in Kentwood, Michigan. He carried heavy emotional burdens. Court papers showed reports of mistreatment and neglect at home months before anything happened. In May 2013, Child Protective Services found marks on his body. They also found filthy living conditions. Those findings never reached the police at the time. His mother and stepfather faced charges later. His stepfather admitted guilt. His mother was found guilty of third-degree child mistreatment in 2015. Those early traumas, plus prescription pills, he had taken some on the day of the incident, created a volatile mix. In late summer 2014, 9-year-old Connor Verkerka and his younger brother were playing on a playground near Pinebrook Village Mobile Home Park. Jamarion joined them. It looked like a normal day. Then things took a tragic turn. He pulled a sharp kitchen tool from his bag. He wounded Connor several times. Police later learned Jamarion had been feeling numb and overwhelmed. When he reached a breaking point, he lashed out at someone who had nothing to do with his pain. Why that playground? Why an innocent child? Jamarion later said he did not plan to end Connor's life at first, but once he reached his limit, he could not stop. He chose someone who did not deserve it. Could a child so wounded grasp what he was doing? He would learn on that swing set. As Connor lay badly hurt, Jamarion's younger sibling ran for help, but it was too late. Connor's heart stopped there on the playground. Afterwards, Jamarion seemed to seek punishment. He asked a neighbor for a phone. He called 911. He confessed. He said, "I did it because I'm fed up with life and want to die." He asked for the harshest penalty. "I don't care how it ends for me. You decide." His words showed a deeply fractured mind. A boy drowning in pain and striking out in the only way he knew. Charged as an adult with a first-degree offense, Jamarion went to trial in September 2015 at age 13. His defense focused on his childhood traumas. They argued he was not of sound mind at the time. He told the court, "I was so scared. I wanted everything to end because I thought there was no way out." Still, the court found him guilty. They saw the horror of what he did, no matter his age or suffering. In court, Jamarion faced Connor's family. With quiet remorse, he said, "I know I was wrong. I do not understand why I did it. I made a terrible mistake. I am sorry for all the pain you have felt." His voice was soft but firm, an apology born of deep regret. The judge gave him a blended sentence. He received probation and time at a youth facility until he turned 21. He did not face a life term. The court balanced holding him accountable with offering a chance to heal. Inside the facility, Jamarion faced dark days. He tried to take his own life. He fought isolation. He took part in therapy. A youth specialist named Frank Briones became his main support. Briones visited each month and offered friendship when Jamarion felt abandoned. His work helped shape the judge's decision for a blended sentence. Through trauma-focused counseling, job training, and schooling, Jamarion slowly changed. By March 2021, 2 years early, he was released just before his 19th birthday. Once free, he did not vanish. He built a support network that included Brione and a woman named Paula Creswell who had written to him. He finished his GED, took college classes, learned woodworking skills, and found a job. His progress convinced Judge Paul Denenfeld that his rehabilitation had been very successful. Connor's mother, Danny, chose forgiveness. She remembered her son as funny and sweet. She honored his memory by extending compassion without expecting anything in return. The next individual warned classmates for weeks. No one stopped him. Evan Ramsey was born in 1981 to Don and Carol. Ramsey in Alaska. His childhood was unstable. When he was 5, his father was sent to prison after a tense standoff with law enforcement. His mother's drinking problems got worse. Not long after, their home caught fire. At 7, Evan and his brothers entered foster care. Between 1988 and 1991, he lived in 11 different foster homes. Some of those homes were places where he suffered mistreatment. That left deep scars. At age 10, he tried to end his own life. Later, he moved to Bethel, Alaska, with a foster mother who became his legal guardian. His home life was broken. His father had taken hostages at a newspaper office in 1986 and spent about 10 years behind bars. A week before what happened at school, Evan's older brother was arrested for theft involving a weapon. These events fed into a childhood marked by fear and neglect. By his sophomore year at Bethel Regional High School, Evan was a known target. Other students teased him. They called him Screech after a TV character. That mockery was both obvious and behind his back. It happened all the time. For 2 weeks before February 19th, 1997, Evan told classmates what he planned to do. At least 2 classmates helped him. One showed him how to load and use the shotgun. Another cheered him on, saying he would become famous. On that morning, he hid a Mossberg 512 gauge shotgun in his pants. He rode the bus to school. He entered the student commons and aimed his weapon at 15-year-old Josh Palacios. Josh had argued with Evan 2 years earlier. Josh was hit in the abdomen. He did not survive his injuries. 2 other students were hurt before Evan moved to the lobby. There he found Principal Ron Edwards. He fired twice at Edwards. Edwards also did not survive. Evan went back to the commons. He fired at responding officers. Then he retreated. He placed the shotgun under his chin, said, "I don't want to die," dropped the weapon, and gave himself up. Why did he do it? Years of teasing and neglect built up inside him. He felt no one cared. He saw his actions as payback for how he had been treated. But the roots ran deeper. He had suffered mistreatment in foster homes. His parents had let him down. That mix of pain and anger pushed him to act. After his arrest, Evan said he did not think anyone could lose their life from what he would do. Prosecutors tried him as an adult. On December 2nd, 1998, a jury found him guilty of 2 counts of first-degree slaying, 3 counts of first-degree attempted slaying, and 15 counts of third-degree harm. The judge first gave him 210 years. On appeal, that became 2 back-to-back terms of 99 years each, for a total of 198 years. He first served time at Spring Creek Correctional Center. Around 2017, he moved to Wildwood Correctional Complex. He will first be able to ask for release in 2066, when he turns 85. In court and later interviews, Evan showed regret. Years later, he added, "A part of me will always be sad. I'm sorry. I wish I could change what happened." Those words carry the weight of loss he can never undo.